I'm Drew Stevenson, and this is a lecture from my professional responsibility class about conflicts of interest. And here we're talking specifically about joint or common representation when you're representing co-plaintiffs or co-defendants, or maybe a group that's going in together on a business transaction. They want to form a business, or they want to invest together in a large parcel of commercial real estate. And so we're talking about Model Rule 1.7 and specifically comments 30 to 32. Okay, so one important factor, a very important factor in determining the appropriateness of common representation is the effect on client-lawyer confidentiality and attorney-client privilege. Now, we're going to spend some time later in the course after I cover conflicts talking about both of these things, about confidentiality and then separately about attorney-client privilege. But I need to preview that for just a moment. So they're not exactly the same thing. They both involve keeping secrets for the client or not disclosing things without the client's authorization. But confidentiality is really an ethical duty, and it's in some ways it's a lot broader than attorney-client privilege, not to disclose things related to that you learn as part of the representation without the client's authorization. Attorney-client privilege, in some sense, is really an evidentiary rule. So it's really about what's admissible at trial, what's discoverable during pretrial discovery, and so forth. Outside of the litigation context, it doesn't really have much real effect. So even though lots of non-lawyers and even some lawyers use confidentiality and attorney-client privilege interchangeably, they're not the same thing. So you could have something that's covered by the duty of confidentiality that's actually not privileged, because privilege has specific rules, and vice versa. You could have something that's privileged that may or may not be covered by the duty of confidentiality. And both can come into play if you are representing multiple clients in the same matter as part of a joint representation. And so when you are getting informed consent at the outset of the representation, this is one of the issues that you need to warn them about. So let's talk about privilege first. Attorney-client privilege, the prevailing rule is that privilege does not attach between commonly represented clients. So this means that you should assume that if litigation eventuates between the clients, the privilege will not protect any such communications, and the clients should be so advised. So I want to explain this or just kind of clarify. Let's say that you're representing two co-plaintiffs. They were riding in a car together. They got hit by a truck and injured, and they want to hire the same lawyer to save money to sue the truck driver for compensation for their injuries. That's fine. The conversations that you have with them privately about the representation will be protected by attorney-client privilege and confidentiality. But let's say the case doesn't work out. It turns out the truck driver is judgment-proof, that somehow the truck driver can show that they had contributorily negligent, the driver of the car, your client. For some reason, they lose their lawsuit against the truck driver. At some point, and this, by the way, happens in real life, the passenger in the car has a falling out with the friend who was driving the car at the time, and ends up, because they have no recourse for whatever reason with the other driver, they sue the person driving the car that they were in. Well, now your clients that you represented together have turned on each other. And that means the conversations that you had with the two of them together, or even with them separately, will not be protected by attorney-client privilege. You could be forced to testify about the conversations at trial. You could be forced to divulge the information, the content of the conversations during pretrial discovery. A privilege will still apply with regard to everyone else. So let's say another third party, the doctors, the physicians who treated them, sue them for unpaid medical bills. Your conversations with those clients will still be privileged. But if your clients turn on each other, privilege will not apply to the conversations that you had with them together or with either of them. Let's give another example that I used earlier when we were talking about conflicts of interest. John, Paul, George, and Ringo come to you and they want you to set up a record label, and they're going to be co-owners for as 4 different ways, right? Each have an equal share. So that's fine. And let's say later on they get in litigation with Apple Computers over the use of the name Apple for their company. Well, all the conversations that you had with John, Paul, George, and Ringo, either as a group or with just 2 of them while the others were away, or even with one of them related to the representation, will still be protected by attorney-client privilege. But if at some point George and or Ringo and Paul sue each other over either royalties of the song, or one of them wants to license one of their songs to a company to use in their TV commercial or marketing or ads, and the other one objects to that, and they end up in litigation, the conversations that you had with them back when you were helping them set up with their record label will be discoverable and admissible at the trial. You could be forced to disclose the information in discovery or during a deposition, and to authenticate it or testify about it at trial. As you can imagine, this is a pretty big issue and a pretty big risk with common representation. Now, let's talk about confidentiality. As to the duty of confidentiality, continued common representation will almost certainly be inadequate if one client asks the lawyer not to disclose to the other client information relevant to the common representation. So the common scenario here is you agree to represent, again, a couple of co-plaintiffs, a couple of co-defendants in a lawsuit, or it could be people going in on a joint venture together, some sort of business transaction, or commercial purchase, real estate purchase or sale. They're selling a business that they co-own. That's fine, but let's say one of them calls you and tells you something in confidence that's relevant to the representation, and then asks you not to tell the other parties that you're representing in the same matter. Well, you can't do that, right? I hope you see the problem is that one of them is asking you to keep secrets from the other. So keep in mind, the lawyer has an equal duty of loyalty to each client. Each client has the right to be informed of anything bearing on the representation that might affect the client's interests, and the clients trust their lawyer, and they have a right to trust their lawyer to use any information about the representation to the client's benefit. So what does this mean? In practice, at the outset of a common representation or joint representation, when you're getting each client's informed consent, part of that, the informed part of that means advising each client that all information will be shared. You're not going to keep secrets between them, and the lawyer will have to withdraw if one client decides that some matter material to the representation should be kept from the other. Now, there's a limited exception that you could see as a test question because it's such a specific exception that it would be easy to turn into a multiple choice question. In limited circumstances, it may be appropriate for the lawyer to proceed with the representation when clients themselves have agreed, after being properly informed, that the lawyer will keep certain information or specific information confidential. So what are we talking about? Well, the comments to the model rules give an example. For example, a lawyer may reasonably conclude that failure to disclose one client's trade secrets to another client will not adversely affect representation involving a joint venture between the clients, and agree to keep that information confidential with the informed consent of both parties. So let's say you have a pharmaceutical company that has a secret process for developing a certain vaccine or drug, and they are forming a partnership with another company that's going to be the distributor of that overseas, let's say, or in Europe or in Asia. And I don't know why, just for purposes of that joint that partnership that they're going to do or joint venture, that you would need to see the or access to the trade secret. But if you happen to get it, the parties have contractually agreed that as part of having the joint representation, that specific information you can keep secret. But notice, this is not somebody calling you after the representation is underway and saying, hey, by the way, I'm going to tell you something, but it's a trade, or send you something and it's a trade secret. Don't tell my partner, who you're also representing in this joint representation, this is something that they've agreed kind of at the outset of the representation. The same would be true with, let's say Coca-Cola has a secret formula that's very valuable, and they form a joint venture with another company that's going to be a new distributor, or maybe incorporate Coca-Cola into another product. So let's say we're going to have Coca-Cola flavored ice cream or something like that from Bluebell. Well, the lawyer may have access to that trade secret, that secret formula, and Coca-Cola and the other party have already agreed that the lawyer will not withhold that information because they don't need it in order to proceed with their joint representation. So just to kind of recap some issues with joint representation, when seeking to establish or adjust a relationship between clients, a lawyer should make clear that the lawyer's role is not that of partisanship normally expected in other circumstances. In other words, you're not going to play favorites or take sides, and the clients may be required, therefore, to assume greater responsibility for decisions than when each client is separately represented. What do we mean by that? We mean that there could be situations if you are representing co-plaintiffs, co-defendants in a lawsuit, or people going in on a joint venture together, co-investors in a business, or people who were co-investors and are now all want to sell the business or property to another, that you're not going to be able to bring up some issues that would really benefit one of them to the disadvantage of the others, because you are loyal to all of them equally. And that means each person in the joint representation is going to have to be a little more proactive about thinking for themselves and looking out for their own interests vis-a-vis the others. Now, with regard to the whole outside world, it's a different story. But with regards to any internal kind of rank or trade-offs between the people in the joint representation, you are not allowed to take sides. So any limitation on the scope of the representation made necessary as a result of the common representation should obviously be fully explained to the clients at the outset of the representation. And that concludes our video about privilege issues and confidentiality that come up when you are doing a joint representation representing multiple clients in the same matter.